Next matter to for the court state of Ohio versus Quon. All right, as you know, each part of the record 2 minutes to present oral argument. If you wish to reserve any time for rebuttal, we have up to 5 minutes. And if you let me know, I will give you time.
Okay, I'd like to reserve 5 minutes for rebuttal.
We've read the briefs, we're ready to move on.
Thank you. May it please the court, I'm Patrick Brown. I represent the appellant Quon Wheeler. Your Honors, this case presents, I think, an important speedy trial issue, somewhat of a novel one. When does the statutory speedy trial clock begin to run, where the indictment precedes the arrest? And I believe that the Supreme Court's holding in State v. Asbell governs that issue, where the Supreme Court held that an indictment is sufficient to trigger the statutory speedy trial clock, and that's right there in the syllabus and the body of the opinion.
You agree, don't you, that the facts are distinguishable from the ones that are before this court?
Certainly, and Asbell dealt with a different issue. In that case, I believe the accused was arrested and then released, and the court there had to address the issue of when does the speedy trial clock begin to run, at the time of arrest or at the time of indictment. When the arrest there preceded the indictment. This is kind of a flip, but the holding on that case still applies here, that the indictment is sufficient to trigger the speedy trial clock in the statute. And I believe if you look at paragraph 3 of Asbell, the state even argued there that the indictment is sufficient to trigger the speedy trial clock, and the court adopted that argument. But there's a second issue here, is when does tolling apply? Okay, and the Supreme Court State v. Asbell did not address that issue. Now, there are a couple of appellate opinions that I believe are highly persuasive on this issue. One from this court on State v. Jalopny, which is a 1982 decision. And there's a decision out of the First District, State v. Sears. And basically the issue is this. When the state makes no effort to serve the warrant, or more specifically when there's no evidence in the record that the state has made any effort to serve the warrant, does the state get the benefit of a lapse in time? Does it get the benefit of tolling? This case is kind of unique because there's no transcript for this court to refer to. We're just looking at the trial docket and the briefs of the parties, basically. So there's no evidence in the record, and it's the state's burden to prove tolling. There's no evidence in the record whatsoever that the state made any effort to serve the warrant in this case. There's no evidence that the state took even the preliminary step of going to the address that it had on file for Mr. Wheeler. And that would have been easy to put in the record. The state could easily have called an officer at a hearing and say, yeah, we got this warrant, and we took it to Mr. Wheeler's residence and couldn't find him. We didn't know where he was. And we had no way to serve on him at that time. That may be sufficient for tolling. The state did none of that. So what that leaves us then is that the speedy trial clock begins to run at the time of indictment. The state does not get the benefit of tolling. And if we calculate the time from the time of indictment in this case, which was May 17, 2014, until the time that Mr. Wheeler filed his motion to dismiss, accounting for tolling for discovery, it's 284 days, which is beyond the 270 days, which means that the indictment should have been dismissed. Now the state is, I'm sorry.
Let me back up. So the indictment issues an arrest warrant is issued.
Accompanies the indictment. Yeah.
Accompanies the indictment. And so your position is that the state needed to produce some witness to say that once this arrest warrant issued, that somebody went out, not just that they were, looking for him in traffic stops, that someone went to his home.
Made some effort to serve that warrant, Your Honor. Didn't just sit on it And I think what happened in this case, well, if it's the record is silent on it, but the state probably just sat on it until Mr. Wheeler got pulled over for some unrelated issue 5 months later, and that's why he got arrested. Yes, that's my position. I think that's the position of the First District in State v. Sears, and this court touched on it in State v. Jalopy, which I know it's about 33 years old at this point. Probably older than I am. But when the state makes no effort to serve the warrant, and the facts in that case are somewhat similar to here, the state doesn't get the benefit of a lapse in time. So yes, it's my position, and it's our position, I believe it's the position of the courts of appeals in Ohio, that the state has to make some effort to serve the warrant. They can't just sit on it. And here, there's no evidence of any such effort. If that's the case, as Bell governs and the speedy trial clock began to run on the date of indictment, which means the state ran out of time when Mr. Wheeler was not tried in time and the indictment should have been dismissed. The state's made a couple of arguments, and the state's position, and I understand it, is basically the speedy trial clock should have began to run at the time of arrest. And it's simply our position that in order for that to happen, you have to make some effort to serve the warrant. The state also noted one other fact in their brief, that Mr. Wheeler's address had changed sometime between the time of the alleged offenses and the time that he signed his recognizance bond about 10 months later. I don't think there's anything remarkable about that fact. People change addresses. I don't think the fact that Mr. Wheeler changed addresses one time in a 10-month span, and we don't know when he changed addresses. It could have been one day prior to him signing the recognizance bond. That's not sufficient to prove tolling. That's not sufficient to satisfy the state's burden. And if the state can't show tolling, then the clock has run out in this case and the indictment should have been dismissed. I raised a second issue, Your Honor, the sentencing issue, but it goes without saying that if the court agrees with us on the speedy trial issue, it doesn't need to reach the sentencing issue. With respect to the sentencing issue, I don't believe the trial judge properly incorporated necessary factual findings into his sentencing entry and didn't state them on the record, but again, that issue only needs to be reached if the court disagrees with us on the speedy trial issue. So I believe this case presents an opportunity for this court to hold, as the First District did in Sears, and to continue with this court held in Jalopy, that the state, when they indict someone, they have to make some effort to serve that warrant, and that just didn't happen here. And I believe that the trial court's judgment denying Mr. Wheeler's motion to dismiss should be reversed on that basis. And this court should follow State v. Asbell. If the state disagrees with that decision, that's something the Supreme Court is going to have to address. But they held that an indictment is sufficient to trigger the clock. That's what happened here. The indictment came first. That's when the clock began to run, and the state does not get the benefit of tolling. So I don't know where I'm at on time.
You are just under 8 minutes.
Okay. At this point, that's all I have to say on the matter. I mean, I know the briefs pretty much speak to this matter, so I'll reserve what time I have left for rebuttal. Thank you.
You may reserve up to 5 minutes. So
Okay.
you have your full 5 minutes.
Thank you.
May it please the court, Mr. Brown, Nathan Shaker, on behalf of the appellee, the state of Ohio. As Mr. Wheeler pointed out in his reply brief, this was solely raised and argued as a statutory issue, as a statutory speedy trial issue. I believe any reliance on the Galati case is misplaced. That is a constitutional speedy trial case. They go through the Barker versus Wingo 4-factor test. It's not looking at the statute. This case was raised as a statutory speedy trial argument, as a statutory speedy trial issue, and so the statute at issue is 2945.71C. And I think as it applies to this case, it is unambiguous. It says a person against whom a charge of felony is pending shall be brought to trial within 270 days after the person's arrest. Asbell is a different case because there was an initial arrest, an indictment, and then arrest. So the Ohio Supreme Court was looking at pendency. It was looking at the first part of C, not C2 in terms of arrest. Asbell is speaking to when a case is pending to start looking at which arrest you look at. Here, Mr. Wheeler was arrested and given a personal cognizance bond on October 24th, 2014. He entered a plea on April 22nd, 2015. 180 days later, 44 days later, he was sentenced. It's clearly within the 270 days as mandated by 2945-71C2 from the time of his arrest. I believe there's a little bit of confusion. It seems like we're moving from 2945-70.72, which has a reasonable diligence requirement for time tolling, and we're somehow imputing that onto the .71 statute. Wheeler hasn't cited any cases that support that argument. What the trial court was faced with was this in 270 days from arrest. The trial court's conclusion was correct. It was from the date of, actually the date of his motion, it would have been far less than 180 days without considering any other tolling provision. I don't believe the trial court erred in that determination. I believe the statute is what governs. Asabel is not persuasive in this case because it deals with pendency. And yes, this case was pending as of the earlier date in 2014, but the 270 days did not begin to run until his arrest. Unless the court has any further questions, the state will ask.
Thank you.
Thank you.
Thank you both for your presentations. The court will take the floor. I'm sorry.
Just briefly, I'm not going to take my full 5 minutes.
That's okay. I'm not going to take it away from you.
Okay, thank you. I appreciate that, Your Honor. State v. Asbell held that for purposes of calculating speedy trial time pursuant to revised code 2945.71C, which is the statute we're dealing with here, a charge is not pending until the accused has been formally charged by a criminal complaint or indictment, is held pending the filing charges, or is released on bail or recognizance. I don't think that's ambiguous. What's that saying is the speedy trial clock begins to run at the time of indictment. If you look at paragraph 3 of Asbell, the state in that case argued that the speedy trial clock should begin to run at the time of indictment.
So you're reading that as 3 separate phrases?
3, yes, there's
You're
a
reading it as one phrase with 2 conditions on that one phrase.
Your Honor is reading it as one phrase with 2 conditions afterwards.
Yeah, because there's 2 ways of looking at it. You can either read it as a phrase with 2 conditions after it, or they're all 3 separate things. Any
Right.
of the 3, or this one plus these 2.
Okay. I understand, Your Honor. I am reading it as either any of these 3 conditions is sufficient to trigger the speedy trial clock. That's my interpretation. And I think that's consistent with United States Supreme Court precedent, which holds that an indictment is sufficient to trigger the constitutional clock, and the Ohio General Assembly would have been aware of that precedent at the time that it enacted the statute. It's also consistent with the fact that the state in Asbell argued that it's right there in paragraph 3 of the opinion, the clock should begin to run at the time of indictment. The Supreme Court agreed with the state.
So wouldn't that kind of mean that you could issue an indictment, and then you could try to serve that thing for 10 years, but you can't get all this extra action and dismiss anyway because you didn't give them this 207 days?
Well, and that is a good point and concern, Your Honor, and I guess the point is that the state makes an effort to serve the warrant, they can't find the accused. They make a good faith
So it
effort.
would expire.
Well, they would be told until they found it. If the state makes a good faith effort to serve the warrant and they can't find someone, the state's not going to be penalized for that. The clock's going to be told until they actually find that person. And I think that's consistent with the reasonable diligence requirement that's in the statute, tolling requirements in 2945.72. It says when someone's unavailable for trial, the clock is told so long as the state exercises reasonable diligence to bring that person to trial. So if the state exercises reasonable diligence to serve the warrant, it's told. It could be 10 years, it could be 20. The state shouldn't be penalized for that, and I agree with that. Here's where this case is different. The state made absolutely no effort to serve this warrant. And therefore, the state does not get the benefit of tolling. And I would look at the First District's opinion in State v. Sears, which I understand is a constitutional case, but it's highly persuasive on the issue of what happens when the state doesn't serve the warrant. Do they get the benefit of a lapse in time? And the answer is no. So I understand Your Honor's concern, and The answer to that concern is that the state makes an effort to serve the warrant. They get the benefit of tolling. If someone goes and hides and tries to avoid service of an indictment, which I'm sure happens, they don't get the benefit of that kind of deceptive behavior. But the state has the burden to show tolling, and the state has to make an effort to serve that warrant. That's our position. I believe that was the position of the court, State v. Sears, and I would ask the court to adopt that position in this case, and I believe this case presents the perfect facts to do that. So I thank you, Your Honor, for your time. Thank you very much.
Thank you. Thank you both.